Hi, thanks for using my court coach. I'm Sarah, and I'll be your instructor today as we talk about the response to petition to determine parental relationship, also known as Form FL-220. You were probably provided this form alongside with the petition to determine parental relationship filed by the other party in the case. As with all our court forms, you want to start off by filling in your identifying case caption information at the top. The rest of the form is essentially responding to everything that the petitioner has marked on their form. So first off, in the original petition, the petitioner has marked some information in this first box, and so you are going to mark your version of facts. If the petitioner, you want to first start off by identifying the role of the petitioner to the case. So if you believe them to be a parent of the child in item 2, mark box 1A. If you believe them not to be a parent of the children in item 2, mark box 1B. If you believe the petitioner to be the child's personal representative, and that was someone that would have been assigned in a different court proceeding, then you would mark box 1C and identify, if you know, the court and date of that appointment. If you believe the petitioner to have some other role in the case, mark box 1D and identify what you believe that role to be. Next, you want to list the children's names, birth dates, ages. If we are talking about a child that is not yet born, mark box 2B. Next, you're going to identify your role to the case and whether or not the court has jurisdiction over you. So if you do live in the state of California, mark box 3A. If you were in the state of California when these children that were listed in item 2 were conceived, mark box 3B. If you do not live in the state of California, mark box 3C. If you were not in California when the children in item 2 were conceived, mark box 2B. If there's anything else, any other information you want the court to know in its determination whether it has the ability to make decisions that impact you in this case, you would identify those in 3E other. Next, we want to respond to the statement about the children and where they live that was raised in the petition. So if the children do live or are found in the county in which this case is being filed, you would mark box 4A. If the children are the children of a parent who is deceased and proceedings for administration of the estate have been or could have been started in this county, mark 4B. Next, as the respondent, you want to state whether or not you are the parent of the children that are listed in item 2 above. If you do believe yourself to be the parent of the children listed in item 2 above, mark 5A. If you're not sure if you're the parent of the children listed in item 2 above, mark 5B. If you just don't believe at all that you are the parent of the children in item 2 listed above, mark item C, 5C. And if there's anything else you want the court to know about your relationship or role to these children, mark 5D and specify what that is in other. There are some additional statements that were included on the petition, and so this is your opportunity to respond to those. 6A, if you believe that parentage has been determined by a voluntary declaration of paternity or parentage, you can mark 6A, and if you have a copy of that, you can attach it to this form. 6B, if you believe parentage has already been established for these children in another case, either a local child support case or some other proceeding, you can mark 6B and mark the appropriate box, which gives information to the court about where that parentage was established. 6C, if you believe that public assistance is being provided to the children, you will fill or mark box 6C. As with the petition, this form is required to have a declaration under UCC-JEA filed and served concurrently with it. That is Form FL-105. And next in field 8, you are going to identify the parent-child relationship to each of the parties. If you believe that either the respondent or the petitioner are the parent of the children listed in item 2, mark the boxes that identify the appropriate parties. If you believe that one or both of the parties are not the parent of the children listed in item 2, you would fill in 8B and I mark the box that correctly identifies the party that you don't believe is the parent of those children. In any sort of parentage case, either party has the right to request genetic testing to determine parentage. So if you want to exercise that right, mark box 8C, and then mark the box that identifies which party it is that you are questioning whether or not they are the parent of the child and want the genetic testing for. Assuming that custody or parentage is established, then you have the right to request certain custody visitation orders. So if you are requesting legal custody of the children, or you want the other party to have it, or if you want to share it, mark the appropriate box that identifies your wishes. Same goes with physical custody. As far as child visitation goes, if you are requesting that one of the parties have primary physical custody of the children above, then the other party should be awarded child visitation below. There are some additional forms that have some very specific provisions regarding custody visitation orders that you can request. You can request it by attaching these forms, filling them out. I generally like to keep my requests for custody visitation in either a petition or response broad, so that I'm not locking myself into anything. But it is entirely up to you. If you do want to use these forms, you certainly are welcome to. Just make sure you're referencing which forms you're attaching to this. Same with providing facts in support of the custody visitation requests. You can see line 9D asks you to provide facts in support of that request. Again, I keep mine pretty simple. I just say best interests of the children. I don't use a declaration to further expand on that at this point. You certainly are welcome to, but I prefer to keep the declarations for either trial briefs or for requests for orders, for temporary orders. But that is your option. If you want to include a declaration that further explains why you're making these requests, you are welcome to. Below, if you are requesting or responding to a request that the reasonable expenses of pregnancy and birth be paid by one of the parties, you can certainly make that request and mark the boxes that identify the parties that you think should share in that cost. If you are requesting attorney fees to be paid by one or both or either of the parties, you can mark box 11A and identify who you want to pay the attorney fees. If you anticipate any experts being appointed to this case, then you can also ask for orders ordering one or both of the parties to pay for that expert. Finally, if you are asking for the child's name to be changed, mark box 12, and you would want to include what their current name is, as well as the name that you're asking it to be changed to. Be as specific as possible with respect to including middle names as well. If there are any other orders that you're requesting pertaining to custody, visitation, determination of paternity, or child support, you can specify that in line 13. Line 14 just tells you that this court, through this establishment of paternity, has the right to make orders for the support of the children. Finally, you will want to print your name at the bottom, sign and date, and this form is ready to be filed and served alongside your declaration under UCC JEA. I hope you found this helpful. Good luck.